this one, Joey says that to me, sorry. This CLE is being recorded. If you would put your screens on speaker view and side by side, that's going to allow you to actually see who's talking and be able to keep track of everybody else that's in attendance. As a reminder, your screens do need to be on for the entire program, which means the picture needs to be on so that we can verify that you're there. We do scrolling throughout to make sure you're there. We also do polling, but occasionally people with the polling have stepped aside just to get a drink of water or something, and that's when they miss the polling. If you are not on video camera and you are by phone, then you need to pay attention to the questions, to the actual presentation, and give us the time that this specific spot in the program starts. And that title is Smith versus Carbon County Board of Assessment Appeals. All right, please make sure you're muted if you're not already so, and stay that way unless you have a question. Generally, questions are at the end, but the speakers usually try to answer them as they go, and if not, they will try to catch them all at the end, and if not, we will get back to you with any questions. As a reminder, big reminder, make sure your CLE forms get back to us in the next business day or so that we can get that recorded with PCAL so you get the proper credit. And if there is no other questions or anything, I'm going to introduce our speakers. You have bios in there. I'm just going to briefly let you know who we have. Chris Brown is a sole practitioner in Stroudsburg. He is the solicitor for East Stroudsburg Area School District and has been so for over 10 years. He is also a solicitor to the Stroudsburg Borough Planning Commission as well as the Monroe County Coroner's Office. He went to Juniata College and also Villanova Law School. Jeff Durney is a partner in Durney, Worthington, and Madden. He also is in a lot of real estate. His bio is even longer, so I'm only going to pick a couple of highlights. He was formerly general counsel for the Shawnee Group Companies. Most of you all know where that is, over closer to East Stroudsburg and in Shawnee, luckily. Makes it a little bit easier. He received his law degree from Emory University School of Law, and he is a past president of the MCBA, and his current partner is the current president. So we're only missing one partner to be president. So that's Jeff's job to make sure Jeff gets on that list of things to do. Bob Kidwell is a shareholder in Newman Williams, PC. He has been practicing law since 2007. He is also a Villanova graduate. Isn't somebody else? Man, I guess that's where that must be the best college of the day. Thank you so much. He is the lead for this program, and I appreciate all of his coordination and everything that he has done. Tom McEwen, a lot of you who are in real estate know Tom very well. Most of us, good or bad, go back a long way, Tom, so I thank you. He is sitting with Jeff Durney today, so you may not see his face all the time. Mr. McEwen has been in real estate and received his license in 1971, and he is one of the probably the most well-known appraisers, I would say, in Monroe County. I've used him several times myself way back when I was in banking. But he actually does real estate in all of the Pocono counties and Lackawanna, Northampton, and Wayne, and Lebanon as well. So with that, I'm going to stop because that's going to take up too much of your time. I'm going to turn it over to Attorney Kidwell, and he will start our program.
Great. Thank you, Denise. Good afternoon, everyone. Again, my name is Bob Kidwell, for those of you who don't know me. And this is a 1-hour CLE addressing residential and commercial assessment appeals. Denise provided some introductions at the beginning, but I did want to make note of the fact that the purpose of compiling this panel was to provide perspectives from many of the interested parties in the assessment appeal process. I represent both residential and commercial property owners in the appeal process. Of course, we have Tom McEwen, who really needs no introduction. Many of you know he performs residential and commercial appraisals and serves as an expert as part of the appeal process. And Chris Brown, who again represents the East Stroudsburg Area School District and will give us that perspective of school districts in general, which of course are the taxing body with the largest stake in these appeals. And we have Jeff Durney, who represents the Monroe County Board of Assessment Revision, and in so doing closely works with the Chief Assessor, City Tribal, who I also believe is is with us today and can provide us that point of view. Presenting information on a topic this broad in only an hour is a bit of a challenge. We've provided a basic outline of what we plan to address in your written materials. We're going to start with the basics of the assessment appeal process, and we'll probably move quickly through that. We don't want this to be too rudimentary for the attendees. And we'll take it from the submission of the appeal all the way to the valuation hearing before the judge. We'll then have an opportunity to pick Tom McCune's brain about the appraisal process and find out from him what he's noticing about the change in the real estate market conditions and how that's impacting his work as an appraiser, especially on the residential side. And finally, we'll get into more complex issues concerning the propriety of using different types of valuation methods, illustrated by cases in your materials, specifically the Downingtown case and cases involving the value in use methods. And thankfully for that, we have a real scholar in this area of the law, Chris Brown, to guide us through those cases. We do envision this being something of a dialogue. So if at any point you have a question, please drop it in the chat. I'll be sure to monitor those questions, as I'm sure my fellow panelists will as well. And with all that by way of introduction, let's get started. We provided a link in your materials to the assessment office's website. And so I'm going to share my screen here if it'll be allowed. And there we go. Now, the appeal process is largely governed by the Consolidated County Assessment Law, which is found at 53 Pennsylvania Consolidated Statutes Annotated Section 8801 at SEC. Our presentation is going to look at the appeal process through the prism of Monroe County. So if you're out of county, bear with us, because we're going to try to look at this from the point of view of a practitioner in Monroe County. And so that's why I've directed everyone to the assessment office website here. I've always found it to be quite useful. You'll see front and center here is the statement that the deadline to file an assessment appeal hearing for 2022 is August 1, 2021. So as a preliminary matter, I would note that that is a Sunday on the calendar. And so Jeff or Cindy, would it be fair to say that the actual deadline would be that Monday, August the 2nd? Not that we want to cut it that close, but is that the actual deadline for filing?
Yes, that is the actual deadline, just like court deadlines that fall on a weekend. We treat it the same way. The deadline will be August 2nd for this year. I did want to highlight one thing while you're on that, Bob. That is the deadline for this year is August 1st, and all appeals must be postmarked by, in this case, August 2nd. Next year, for appeals beginning to be filed by August 1st of 2022, they are going to have to be received in the assessment office by August 1st, not postmarked. So that will be prominently displayed and advertised, but I just wanted to, while we have the opportunity, make that announcement now that there will be a change in policy beginning with the tax appeals for tax year 2023. And they will have to be received in the office by August 1st of 2022. One other point on the deadline. The August 1st deadline is a statutory deadline. It is a hard deadline. If an appeal is received late, the office will reject the appeal. We have had a couple of nunc-pro-tunc appeals filed. We had 3 or 4 filed last year with people saying things like, I did not file my appeal by August 1st because I was waiting to get my school tax bill, which didn't come out until August 1st. Therefore, I didn't have a time to file my appeal. Each of those nunc-pro-tunc appeals was denied by the court. The court, I think consistently, and certainly our position is that is a hard deadline. So make sure you comply with it.
Yeah, no, thank you for that, Jeff. And inherent in the statement that's on the website here is that this is a hearing for 2022, meaning that these appeals, and I'm sure many of us assembled here today appreciate, are prospective in nature. meaning it's only going to impact next year's taxes. As Jeff just alluded to, oftentimes I'll have a client contact me after receiving a tax bill and wanting to file an appeal to reduce those taxes. And I need to explain that there's probably nothing I can do about this year's assessment, absent facts that might support an appeal to nunc-pro-tunc. But as Jeff again just indicated, those have been met with very little success, at least recently in the court. Before we delve too much into the appeal process, speaking of tax bills, it might be a good opportunity to kind of address why our taxes are so high. I'm often asked by prospective clients why our taxes seem so out of whack with neighboring counties. And so, Attorney Brown, I'll turn the floor over to you. Do you want to provide some background on this topic, since the answer really involves the school districts?
Yeah, the answer is the school districts, right? Yeah, and because this is something that arises a lot with assessment appeal clients, where they say, I need my taxes reduced. It's unfair. I'm paying $8,000 on a regular Joe's house. That can't be right. And we always have to advise them. Unfortunately, it is right. You've got a market valuation on your assessment there. This is why, and feel free to explain this to everyone under the sun, because the more people who know about it, the better. In 1991, the General Assembly went about providing state funding for school the way they do, which is they allocate a big pile of money and they divide it among the Commonwealth's 500 school districts based upon the number of students in each school district and then various other socioeconomic considerations. What they did different in 1991 was they also put in a provision that we call the hold harmless provision, and it says that no school district will ever get less funding than they are right now in 1991. School districts liked this, or they thought they liked it, because it gave them some cost certainty. They weren't going to have wildly fluctuating state subsidies. Here's the problem with the hold harmless provision. In practice, how the General Assembly handled that was every year after 1991, they just kept allocating based upon the number of students each school district had in 1991. So that means all the way up until 2015, all of the Monroe County school districts were getting money from the state as if they had the same number of students as they did in 1991. I would guess that everyone here knows that all of the school districts had wildly more students in 2015 than they did in 1991. As a result, Monroe County's 4 school districts get much less from the state than the average school district. And the question arises, well, why don't they just change this? It's obviously unfair. And the answer is because most districts in the Commonwealth ended up slightly better for having this. So there's a small number that are getting crushed, like all 4 in Monroe County, basically anywhere where you had dramatic population increases over the last 30 years. But you can't get it through the General Assembly. So we're stuck with it. In 2016, they created a new thing they call the fair funding formula. And it basically does away with this hold harmless provision. It says we're going to start allocating funds based upon the actual number of students, not the number of students you had 30 years ago. But that only applies to new programs and new money. So as of today, in 2021, 90% of school funding is still based on the number of students that each district had in 1991. And that's it. It's not our fault. That's what I'm saying.
All right, very good, Chris. Thank you. Turning back to the appeal process, you'll note on the assessment office website, there is this section for forms. We're going to briefly go through the top 3 bulleted items here. Your 2022 commercial appeal form, your 2022 residential appeal form, and then this document, the 2022 appeal procedures, rules, and regulations, when we discuss the actual hearing that takes place before the Board of Assessment Revision. So quickly, just on the 2022 commercial appeal form, there are a set of instructions at the outset. And of course, Jeff or Cindy, please feel free to interject. I am going to turn the floor over to you momentarily to ask you about any potential pitfalls that practitioners can fall into when preparing these appeal forms. But as far as the commercial form is considered, there's a $50 filing fee that is per parcel. So if you have a client, a commercial client that has several adjoining parcels as part of one larger contiguous tract, you're going to have to prepare multiple applications and submit multiple fees. Obviously, in the appeal form, you need to identify the property, provide the type of commercial use that you put that property to, provide an opinion of value, should you have an opinion at that point in time, and we'll get into that momentarily. The assessment office is looking for mortgage information. So if you have financing, you have a mortgage against the property, they want to know the terms and the interest rate. If it's a rental unit or apartment building, for instance, they want to know the number of units and the rent that is being paid. And then finally, there's a 3-year annual income and expense information that they look for as well. Candidly, I don't always have that information at the ready when I submit my my forms on behalf of my clients, but I supplement it typically when the appraisal comes in. Turning quickly to the residential appeal form, you'll note here in the opening kind of paragraph, as was the case in the commercial appeal form, the deadline is provided as August 1st. The fee for this is $25 per parcel. There is an underlined statement here, which is also in the commercial form, that no faxes or emails will be accepted. I won't highlight, but it's there. You have to, again, identify the property, provide a description of the property, and all of this information would be set forth in your appraisal if you had it ready at the time that you submitted the application. If the property is rented, then they want to see the lease. So those are the two appeal forms. I'm sure many of us are familiar with those forms. I'll turn the floor over to Jeff or Cindy and just ask generally, what is it that the assessment office is really looking for with these applications? What are the common pitfalls that attorneys or property owners can fall into? And why is it that we have to sign our names in blue ink? I never understood that requirement.
Well, let me take the last question first. That is, why blue ink? And that's simply a matter of the assessment office wants to make sure they know which version is the original. Having blue ink, I'm sure another colored ink would be okay, but blue ink at least gives us the ability to identify which submission is the original for purposes of our record keeping. Multiple copies are made of the submission, so we just want to make sure we always know which one's the original. The forms themselves, I think, are fairly straightforward, so I don't know that I have a whole lot of comment on that, but let me talk for a couple of minutes about the rules and some of the things that are important with regard to your submissions. The first thing to remember is the purpose of the hearing is to determine the fair market value of the property. That's the only issue when you make an assessment appeal. What is the fair market value of the property? The taxpayer has the burden to establish the assessment is too high. How do they do that? The proof and the gold standard, of course, is an appraisal. The owner may offer, by case law has established, an owner may come in and offer testimony as to how he or she believes, or what he or she believes the value of their property may be. But I will tell you that both the board and the court are typically not swayed by Zillow, by a taxpayer coming in and saying, my neighbor's property is sold for this, or my neighbor's house is much nicer than mine, so we should make an adjustment here. What the board looks for, and again, by extension, the court subsequently looks for, is an appraisal. They want to see what a professional appraiser has to say about the value of the property. We have had occasions where people have come in with CMAs, comparative market analysis, prepared by a realtor. Again, the board does not view those with a great deal of belief that there's value in there. They want to see an appraisal. So if I can try to encourage everyone, have your client spend the money on an appraisal. Get the appraisal done. There's three particular points in this appeal process where that becomes critical. Point number one is at the hearing before the board. If you have an appraisal and you go in front of the board will, of course, consider that appraisal and potentially adjust your assessment accordingly. Number two, if you're unsatisfied with the result at the board level, you can file an appeal to the Court of Common Pleas. If you are going to go before Judge Zulick, who handles 98% of the assessment appeals, Judge Zulick is going to want to see an appraisal. Number three, whenever there's an appeal filed after the board makes its decision and an appeal is filed to court, there's always an opportunity to engage in settlement negotiations with the assessment office. The chief assessor is not going to be able to make adjustments to your assessment unless she has an appraisal. She has people she has to answer to as well. As you can imagine, she's got to justify to the county commissioners first, and then subsequently perhaps to the school district and to the municipality as to why she made an adjustment in someone's assessment. She needs to have the backup and needs to have an appraisal so that she can make that determination and potentially settle an appeal. So it's critical to have an appraisal to go through this process. The hearing is established, again, is only to establish fair market value. That's the whole purpose here. It is not an appeal of your tax bill. The assessment office does not bill or collect any taxes. The purpose of the appeal is limited to establishing fair market value. One other thing just to highlight that most of you who've done this before are aware of, when you file an appeal, it is possible that your assessment can go up. If a client has put an addition on or finished off a basement or something like that, and that information is not in the assessment office's records, it's very possible that the assessment could go up. When I was on the other side of the table representing private taxpayers, I would always ask those questions before we filed an appeal. Have you made any additions? Or is there anything in that's not included in the assessment record, so that walking in the door, I'm okay. I'm not going to get the unhappy surprise of my tax assessment actually going up. We had two trials last year where that happened, where both taxpayers who were pro se appealed their assessment, and the county obtained an appraisal, and the appraised value was higher than the assessment. One case settled in the middle of trial when the pro se taxpayer realized exactly what was likely to happen. The other one went all the way to a decision by Judge Zulick, which ended up with an assessment that was higher than where we started. So again, it's somewhat rare, but always be aware that your assessment could go up. A couple of quick pointers on appraisals. Bob already highlighted the fact that there's something in there that says do not email or fax. There are two primary reasons for that. The first reason for that is many times an email or a fax is not particularly readable. Faxes in particular, when things are faxed in, not only does it come in somewhat unreadable, somewhat blurry, but one of the important things that from the assessment standpoint is when you're looking at appraisals, you're looking at comparable properties. And we have to be able to see what the comparable properties really look like. An email or fax often doesn't do that. Number two, when you send an email or a fax, you are asking or that the assessment office bear the burden of copying and distributing and all that, using its color ink, using its copies, things like that. The burden is not tremendous on the taxpayer, but it is there that you are to submit an original and the requisite number of copies, and at least one of the original needs to be in color, so that the assessor can try to really make sure that when they're looking at things that their comparables truly are comparables, and we need to be able to see the photographs. Provide the appraisals at least 10 days prior to the hearing. Again, try not to, and I know, and this is, I'm sure, something we'll hit on, when everybody is busy and it's very difficult, it's hard for the board to be prepared for a hearing if they only are handed the appraisal as they come in the room to do that. So if you get the appraisal in at least 10 days ahead, that gives the board the ability to look things over. It also gives the assessment office an opportunity to do all relevant field inspections of the property. So please try to do that. If you're going to appeal, start early. Appraisers are busy. Make sure you get to them early on so that you can keep things moving along here. Bob, that's what I had by way of a couple of pointers. I don't know if there's anything else you anticipated you wanted me to cover.
Hey, just a couple questions, Jeff, about this. Under the rules and regulations that are posted on the assessment office website, it provides in here that the board may examine the appellant or witnesses appearing on the appellant's behalf and may require the appellant to furnish additional information or data for consideration in arriving at the opinion of fair market value. So I'd be interested in your insight and perhaps Tom McCune's insight as to whether it's necessary in the board's estimation or just advisable, given that requirement or that explanation that the board may seek additional information or data. Should we have the appraiser testify before the board if possible? What would the board's position be on that? And certainly I would welcome Tom's thoughts on that as well.
The board would always prefer to have the appraiser there to testify. Again, I think it certainly helps. Obviously, when somebody like Tom, who the board knows very well because he's been in front of the board for many years, it may not be quite as necessary because they understand how Tom does his work. But certainly, it's helpful for the board to be able to discuss with the appraiser, if they have any questions, why do you have this as a comparable property when it's 5 miles away, or things like that. So I always think it is useful to have the appraiser there physically to testify. Now, I do appreciate the fact, particularly in residential appeals, that there may be an additional cost to the client to have testimony there. Again, I think it's valuable. I think it's money well spent. But the client will have to make that determination. It's not mandatory, but it certainly is something that we would like to see.
And Chris, if you wouldn't mind, do you ever participate at the Board of Assessment revision level on behalf of the school district? And if so, what is it that triggers your involvement? Is it the value of the property or some other factor?
Yes, so we do. And the East Stroudsburg School District has a specific policy set by the school board that directs when, in the opinion of the school's business office and the school's solicitor, the district has more than $10,000 in tax revenue per year on the line in a given case, that we are to participate. Again, that's just East Stroudsburg. I don't know how the other 3 districts handle it.
Okay.
And of course, that's more art than science at the very initial stage, because how would we know how much we have on the line? So sometimes you won't see us at the board, but we'll see the board result, and maybe you'll see us at the appeal stage.
Okay.
Before the common pleas.
And so at some point in time, the board will issue a written determination on the appeal and provide that there's 30 days to appeal to the county court. I'm assuming that most of the people who are assembled today know what this process looks like. We file a petition with the court, we attach the board's written decision, and we serve it on all the taxing bodies. From there, the court will schedule a status conference where the parties can discuss deadlines for appraisals and potentially a trial date. Now, after the reassessment, the county did pay for the parties to mediate the appeals to cut down on the court's docket. Jeff, quickly, I mean, how successful do you think that mediation process was, given that you probably participated in more of them than anyone else in the county, Cindy included? And where does mediation stand currently? I assume the county is not going to be subsidizing mediation moving forward.
That's correct. Number one, I think the mediation process was extremely successful. Just so you have some numbers, for the first year of the reassessment, which would be the 2020 tax year, we had 5,700 appeals that went to the board. And from the board, 950 were appealed to the court. So we had about 950 cases slapped on the court's docket all at one time. So the mediation process was almost absolutely necessary to how do we figure this out? So we had Judge Cheslock and Alan Young as the mediators, and we scheduled mediation usually 3 days a week, and we're able to settle the lion's share of the cases via the mediation process. In 2020, for the 2021 tax year, we went from 5,700 appeals filed to the board down to about 600. And from the appeals from the board to the Court of Common Pleas, we went from 950 down to about 80. So again, the commissioners at that point in time, given the expense involved with the mediation process, and now feeling the need wasn't really there, given the numbers, we had less than 10% of the number of appeals we had in year one. So there is no formal mediation process in place right now. And I don't envision that in the future unless we have another extraordinary spike in the number of appeals.
And finally, if the parties are unable to reach a resolution, we know that this will result in an evaluation hearing before the court. Jeff or Chris, either of you can chime in here. How many trials do you typically have in a given year? And can you just describe generally what that trial looks like? I mean, what is it that the judge expects from the parties when he's having an evaluation hearing?
Well, I will tell you from our standpoint, we only have usually a few trials a year. We've been very successful in resolving these. Again, when taxpayers come in with appraisals, and particularly when they're represented by counsel, we and the school district will often have our own appraisers either issue a report or at least review the taxpayer's appraisal. And we're able to come up with usually a path forward to try to get these cases resolved. So I've averaged probably no more than 5 a year in the years I've been doing this that have actually gone to trial. And frankly, most of them probably have been pro se that have been difficult to settle just because of the nature of the pro se litigant. The trial itself is fairly straightforward. The initial burden is on the county to basically place the assessment record place the assessment card as of record. That's the county's prima facie case. All we do is establish here is the assessed value of the property and a little bit more information, and then the burden shifts to the taxpayer to go ahead and present its case as to why the county's assessment is too high. The judge will then take the taxpayer's expert testimony, typically an appraiser, then turns back to the county and school district and says, put your evidence on, we put on our appraiser, and then the judge makes a decision from there. So it really is truly a battle of the experts there. It's just typically two appraisers testifying. Some of the commercial appeals there can be more factors that get a lot more complicated, and there can be some additional testimony that's necessary. But at the end of the day, the court's decision, the court's role is to make a decision, what's the fair market value of the property? And as I say, they're going to look at the competing appraisals. And the judge is free to decide any way he or she desires on that issue. The judge doesn't have to accept one appraisal versus the other. The judge can take a number in the middle. The judge could take a number above or below. So there's nothing that restricts the judge in how he or she is going to rule on that issue.
Okay, and we're going to talk appraisals next, Tom, so be ready. We do have a question in the chat. Let's address that before we leave the appeal process. The question is, I understand the property owner must submit an appraisal in advance. Why does the county withhold its staff recommendation until the time of hearing? Why does the county not present its own appraisal in advance? Jeff, can you quickly address that?
Sure. The way the process works is that, remember whose burden it is. The county doesn't have to establish anything other than to say, this is what the assessment is. It's the taxpayer's burden to establish that the county's number is wrong. So the taxpayer goes first and says, here's our expert testimony, or here's our expert opinion on what the value is. The county then typically, what will happen is at least when the case has been appealed to court, what we will do is we will look at the taxpayer's appraiser, evaluate that appraisal, and then go ahead and make a decision as to whether we might be able to have some settlement negotiations prior to the county going forward or the school district going forward and obtaining its own appraisal. If we are unable to resolve, of course, we go forward and we get our appraisal. As I said, the process has generally worked pretty well. I understand the frustration sometimes on the part of the taxpayer who says, well, I've given you our appraisal, where's yours? But the way the process works and the way the court order comes as a result of the status conference, the judge will tell the taxpayer they've got to produce their appraisal by X date, and then the county and school district has to produce their appraisal typically 60 to 90 days later. So I understand the frustration, but I will tell you the process does work. If you give us an appraisal, we will absolutely have it reviewed and take that under consideration before we, as we go ahead and enter into settlement negotiations.
And that's a good segue for us. So obviously the appraisal is the most important aspect of the assessment process. And thankfully we have Tom McCune to share some of his expertise. So Tom, what do you need or look for to get started on an appraisal that you know will be used as part of an assessment appeal?
Well, typically it starts with a phone call. Somebody, usually when the tax bills come out. And, I'll do a little bit of checking while I have them on the phone. I'll pull up their information that's on record. And in some cases, I can tell whether they have a case or whether they don't have a case. The primary thing we take a look at is value. However, one other aspect that does come into play in many cases is the square footage of the property. The assessor's office is somewhat, their hands are a little bit tied. Typically speaking, they will get the footprint of the home or the structure. The footprint is usually right on target, but in many cases, they don't have access to the interior of the building. So the second floor, they typically do on a percentage basis, which is anywhere from 100% of the first floor to 40% or 60%. But without getting inside and being able to get the measurements of the second floor or whatever, it is an area where the square footage can be different when we actually go out and physically measure the building. But the first part is we'll just talk in general. Many of the calls that we get are people that are dissatisfied with the amount of their taxes or the amount of the increase. And I try to politely tell them that I can understand your frustration, but that's not what the hearing is about. We're dealing totally with appealing the assessment if we feel it's too high. And in many cases, it might end there. We probably turn away, I would say, a good 40 to 50% of the people that call us. They just flat out, they might not be happy with their taxes, but they do not have a case that they're going to win. In the other cases, we can't go any further until we actually do the appraisal. Where, if it's a more complex property, we need to go out, inspect it, inspect the leases, see what sort of cash flow they have, what sort of vacancy that they have. And we can't really tell until we actually finish the appraisal. And at that particular point, we'll discuss with the applicant whether or not it's worthwhile going forward or not. And in most cases, once we reach that particular point, in many cases, they do have a case. And if they don't, we just tell them, hey, look, this is how you find out. And a lot of times I'm asked to see if they have a case before I even take a look at the property or any of the figures. And I just have to tell them that, I just can't do that. Until we get into a more complicated property, I just don't know. And what is we're finding we're doing more and more commercial on a percentage basis than residential, because as everyone is probably aware, the residential market is just skyrocketed as far as values are concerned. And so with the original reassessment, most of the residential figures seem to be pretty well in line. There were, a lot of the values that were overstated originally, such as Great Bear or Blue Mountain Lakes, they came down accordingly. And so I think overall, with the reassessment, the residential appraisals, there weren't nearly as many that where there were complaints or where they had a case. The commercial seemed to be on the higher side. But what we are finding right now is that the probably 80% of what we're doing is on the commercial end.
And is that attributable to the changing real estate market and how hot the market is right now? I would imagine, and I wonder what your opinion is, what that's going to do to residential appeals this year specifically.
Well, we don't have that many residential appeals this year. I mean, that's the main reason why. I think with the original reassessment, the values weren't bad to begin with. They were pretty representative. And now with the market booming, most residential cases typically don't have a case. I have one that I'm dealing with right now, and the gentleman just keeps talking about how much his taxes went up. And I'm looking at his home. It's 10 acres and 4,000 square feet. And the assessment, at least from what I'm taking a look at it, I told him, so at least from what I'm seeing, I said, it's highly likely that you will not have a case. And, he's adamant. So I said, well, if you want, we could do the appraisal on it, but I'm not optimistic. And then I leave it up to them. And if we do the appraisal, we would then recommend to them, hey, we would not recommend going into court. You do not have a case.
On the commercial side, if there's a situation where you have a unique commercial property that might not have any comps in county, what's the propriety as far as in your field and with the courts as to going out of county for those comps?
Well, it depends on the nature of the subject property. If you deal, and the choice of comparable sales is rather simplistic when you take a look at the overall view of it. When you deal with a 3-bedroom, 2-bath ranch in Stroud Township, not only is there no need to go out of the county, you're probably derelict if you do go out of the county. There's plenty of data here, and anybody that's looking to purchase a home in Stroud Township, there are plenty to choose from, plenty of comparable sales to choose from. Now, however, if you're dealing with a resort, you're only going to have so many resorts in the area that are still open, that is. And you take a look at your body with your comparable sales. When I pick out my comparable sales, the logic that I employ is this, is that if these sales were available to be purchased today, that they would appeal to the same market. And that kind of narrows it down in the sense that are the comparable sales going to be different? Sure. But if they're competitive with our subject, even though they're different, that's where the choice comes in. It would appeal to the same market and would be competitive with our subject. So if we take a look at a large commercial property, you might have limits as far as what's available in Monroe County. So that is the time where we would explore. If we were dealing with a hotel, then that is where we would probably go outside the county. We would take a look and see what's in the county, and then explain why we're going outside the county, because in all likelihood, we probably would get some more representative comparable sales that way.
And before we let you go, Tom, I'm looking at the chat, and I think Cindy addressed one question that was posed to the entire group, and I appreciate Cindy graciously responding to that. There was a question that was sent directly to me, and the question is, what is the method by which the fair market value is looked at with regard to strip malls? Income, sales, comps? So without getting overly specific, if you were to have a strip mall client approach you, is there a particular valuation method that you think would be preferable or more persuasive when you take that as part of the appeal process?
Well, generally speaking on this, both approaches, the sales comparison approach and the income approach, will have significant weight in that particular appraisal. And the larger the strip mall is, or the shopping center, whatever it might be, the more income it produces, and the more weight you place on the income approach. That's what people will be taking a look at, is what's the net operating income, which we then would capitalize into a value. We'll take that stream and capitalize it into a value. But there are a lot of different aspects that we take a look at. One, we want to take a look at what's the vacancy factor, and how is that representative of market? And then we'll also take a look at the rents. What is your contract rent? If you're locked in to a 15-year lease, then we're not all that interested in what the market rent is, unless the contract rent is significantly higher than the market rent. If indeed that's the case, you're dealing with what we call excess rent. And when we deal with that excess rent, we will not capitalize it at the same value or the same percentage rate that we might at market rent. And there are certain examples that we've used with that, because that rent is not as reliable. If you have a tenant who's in a 15-year lease, and it ends up that over time they're end up paying a considerable amount more than market, you can better believe that at some particular point, they're going to be approaching the owner to renegotiate that lease. So we take a look at the contract rent, how it relates to market rent, and if it's generally speaking in line, then we go with market rent. And those that are below market on a short-term lease, we might employ market rent on that. So it all comes into play. Each one has its own little variances regarding it. So we're going to take a look at the sales comparison approach, typically on a per unit basis. If there are too many units, we'll also take a look at it on a per square foot basis. And then we take a look at the income. And now the income, we typically will take a look at it two ways. One with a typical capitalization rate, which in many cases, just to use the figure, it's not locked in, but generally 8 to 8.5%. But since the purpose of the appraisal is for a tax appeal, the real estate taxes are typically the major expense, that we take into consideration when we finally end up with the net operating income. So we will typically do two approaches. One, the typical approach that everybody's familiar with that includes the real estate taxes. And then we'll do one where we exclude the taxes because we want to remove that influence from the final valuation. So to compensate for that, we typically will take a look at our original capitalization rate, which might be, say, 8 or 8.5%. And then we take a look at the millage for that particular municipality. We're going to take a look at the overall millage, the county township millage, along with the school district millage. And if it's 35 mils or 0.035, we might take that and then add that to our original capitalization rate of 8 and have what we call a loaded capitalization rate of 11.5%. So we'll do it that way also. And that tends to, in many cases, that will tend to give a more representative figure once we remove the influence. Because I have one I'm working on right now where, including the real estate taxes, I think I was right around $800,000. Well, if we did not put in the loaded capitalization rate, and the assessor's office and the school district agreed with us, well, that would automatically raise the value of the property. So what we do in the loaded capitalization rate on the same property, by removing it, we came up with $965,000, which is probably a more representative figure for tax appeal purposes. So it's both approaches, the income approach and the sales comparison approach, absolutely come into play. Some more so than others, depending upon the particular property.
Thanks, Tom. And at the end here, with the last 9 or so minutes, we're going to turn the floor over to Attorney Chris Brown for him to lead us in a discussion of the Downingtown and the value and use cases jurisprudence. So Chris, with the 8 minutes we have remaining, do what you can to try to, at least explain what those valuation strategies and methods look like.
Right. And then that's perfect because we're just going to do a primer. I'm betting there's entire CLEs just about Downingtown arguments and value and use, but we don't want to do that today. So when you practice in this field, you'll hear other practitioners talk about a Downingtown argument. They're going to make a Downingtown argument. And so I just wanted to go over what exactly that is and what the state's law, quote unquote, Downingtown argument is. To do that, you need a little bit of history. And I don't think we've made this explicit today, but the simplest distillation of a assessment appeal is Tom tells us what the fair market value of the property is with his appraisal. We multiply that by the common level ratio. That tells us the assessed value. That is, per the statutes, exactly what Judge Julik is supposed to do. And that's what we do. But before 1982, there was no such thing as a common level ratio. So how did taxpayers challenge their tax assessment if there's no common level ratio to convert a fair market value appraisal into what my assessment should be? And there was a string of cases directing litigants how to do that. And essentially, the courts were telling litigants to do what the state does now to calculate common level ratios. You take all of the sales over, say, the last year in a county, and you compare that, you divide that by the assessed value, and that gives you a ratio. You average out all those ratios, and then you get what the district's common level is. And that is essentially what the state does now to give us common level ratios. Now, when in 1982, when they started doing common level ratios, the question was presented, and it's the main question in the Downingtown case: hey, can I still make my own common level? Not counties do. And the Supreme Court in Downingtown answered that question: yes, you can. And the reason they gave is because there are certain underrepresented classes of property that maybe the common level ratio produced by the state doesn't capture. And what they mean by that is essentially the common level ratio is dominated by residential sales. And so if you have a unique, unusual property use, the value is not going to move with the common level ratio. Maybe it moves down when residential values are going up or ever. And so the Supreme Court said, yeah, you can still make your own common level. What you need to do is demonstrate the assessment to value ratio of similar properties of the same nature in the neighborhood. That's what the Downingtown court said. And so the two following cases kind of demonstrate how that has played out. First is the Chartiers case that's in the materials. There, the taxpayer owns an office building. The common level ratio there was 100%. And the taxpayer came into court with 15 what appear to be randomly selected deeds from the county and said, well, we took these 15 and we compared them to the assessment, and it shows that it's not actually 100%, it's 60%. And it turned out that they were almost all residential properties. They weren't in the same neighborhood as the subject office building. Obviously, they're not even similar. And so the court said, no, that is not what Downingtown's telling you to do. You need to be in the same neighborhood, and they need to be similar in use. And we would consider that. And so the taxpayer lost. They failed their Downingtown argument. The next case, Smith versus Carbon County Board of Assessments. This one's interesting because it looks like the taxpayer did exactly what the Downingtown court told them to do. Mr. Smith owned a condo. There, the common level ratio was 33%. But he showed all of the identical condos in his condo building that had sold over the last few years, compared them to their assessed value, and showed that in that condo building, everything's valued at 20% of fair market value. So you can't use the 33% common level ratio for these condos. To treat me the same as the similar properties of the same nature in my neighborhood, you're going to have to use a 20%. Again, seems to be exactly what the Downingtown Supreme Court said you should do, but the Commonwealth Court rejected it and said, no, we're going to use the common level ratio. You don't get the benefit of the assessments in your condo. And the rationale seems to be that it's unfair to the county as a whole. So you're creating your own common level level ratio just for your apartment building. And while that would be fair just in the apartment building, you need to be paying the same rate as everyone. And that's the point of the common level ratio. So it almost feels like Smith has undone what Downingtown did. There's been attacks at the edges on the Smith holding, but no case, the Supreme Court hasn't seen to overturn it. So right now, when you hear people talk about they're going to make a Downingtown argument, one raisin brow, because it appears under the law to be extremely difficult to do. And finally, value and use. So this is a thing that comes up all the time, especially in commercial appeals, or really only in commercial appeals. Value and use is a prohibition directed primarily at appraisers. The gist of it is this, and it's in the cases there. The use of specific income of a specific user of a property is simply not. Now that sounds like it flies in the face of what Tom just was telling us about how in a strip mall situation, the number one consideration is what is that NOI? And so you kind of got to dive into the cases to see exactly what they mean by the use of a specific income of a specific user. So the first case in the materials is Hershey Park, and that one seems pretty straightforward. In that case, they were trying to count the ticket sales and the chocolate sales and all of that sort of stuff at Hershey Park. Add that all up and then play as the assessed value of Hershey Park. The court said, no, you're not valuing real estate there. You're valuing how well Hershey Park runs its enterprise. You get to the next two cases, which I'll just group together, but the gist of it is those were rental values to a landlord. So as far as the owner of the property goes, all it is an income stream. In those cases, you do use the income stream of the owner landlord. That is not a value and use situation. So I sum it up as this. When you're valuing commercial property, you never want to count how many hamburgers are sold, but you want to count how many dollars come to the property owner. That's the short version.
Well, thanks, Chris, for tightening that up for us. I hope everybody found the presentation informative. Again, we were somewhat limited on time, so if we didn't address a topic or an issue that you were interested in and have a question, please feel free to send an email to any one of us, and we thank you for attending.
Thank you all very much. Just a quick reminder to send in your CLE forms. And if you really want another round or a little more in depth, let us know. Maybe we can sway these gentlemen into doing a part 2 in the late fall or something like that. Again, thank you very much. Make sure you send your forms back to Lori at info@monroecountybar.org. You think I know that by heart. Thank you all very much and have a safe and wonderful weekend.